Hello, everyone, and welcome to a different ballgame, Depositions at the PTAB and District Court, the final webinar in Virtual Patent Gateway's PTAB Practitioner Series for 2021. Today's webinar is hosted by Virtual Patent Gateway founder Ashley Chung and generously sponsored by Hughesby Global Litigation. And joining us today is Jennifer Rochfort, an account executive experienced in the court reporting industry. Virtual Patent Gateway, VPG, was founded in January 2020, right before the pandemic, and Ashley has a passion for supporting PTAB practitioners and is committed to developing a growth mindset within VPG. Joining us today is Josepher Lee, an attorney at Armond Wilson LLP. Josepher is a technical attorney focusing on high-stakes IP litigation with an emphasis on patent, trade secret, and copyright disputes. He counsels clients on offensive and defensive pre-litigation strategies, validity, infringement, and patent protection strategies. This webinar will be recorded for future use and available on YouTube following the webinar. We have applied for 1 hour Virginia CLE, and Ashley will notify you when it is approved. There will be a short Q&A at the end of the presentation. And with that, I'll hand it over to Josepher.
Hi, everyone. Good morning or good afternoon, depending on where you are today. Thank you very much and in advance for attending today's webinar. And a big thank you, of course, to Ashley and the Virtual Patent Gateway team for organizing all of this. Today's webinar would obviously not be possible without their support. So my name is Josepher Lee, and as you may have guessed from the title here, today's webinar will be about depositions at the PTAB. So just a little bit of background about me. So I'm a litigator and a registered patent attorney at the law firm Armond Wilson, based in Newport Beach, California. And previously, I was associated with the Orange County office of the law firm Kenobi Martins. Earlier in my career, I did a mix of both litigation and patent prosecution. And today and for the last several years, my practice is focused solely on litigation, mostly district court patent litigation and IPRs at the PTAB. If you haven't heard of Armond Wilson, we are a firm of litigators and trial lawyers specializing in intellectual property matters, including district court litigation, federal circuit appeals, and of course, IPRs and other post-grant proceedings before the PTAB. If you're looking for more information about us, you can find us on the web at www.armondwilson.com. So again, today's webinar is about PTAB depositions and specifically the strategic and procedural considerations that PTAB depositions present. The focus will be on PTAB depositions of expert witnesses, which is obviously by far the most common type of deposition you'll encounter in an IPR. And where possible, I'll try to point out some of the relevant differences between your typical PTAB deposition and a typical deposition in district court. So we'll try to cover 4 topic areas today. Deposition logistics, including things like how to schedule or set up the deposition. Deposition mechanics, including things like how to make objections during the deposition. The role of PTAB depositions. And finally, some strategic considerations for PTAB depositions. Now, of course, given the limited time we have during this webinar, we won't cover everything there is to know under each of these umbrellas. The purpose of this webinar is more to highlight, some of what makes a PTAB deposition unique or different. And so with that, we'll get started on our first topic, which is deposition logistics. So for those of you who are new to PTAB depositions, most of the rules governing depositions can be found in the Code of Federal Regulations, 37 CFR section 42.53. And that section of the CFR is actually very helpful and includes the information shown here on this slide, including that a deposition should ordinarily be conducted more than a week before the filing date for any paper in which the cross-examination testimony is expected to be used. Now, regarding the filing date for any paper in which the cross-examination testimony is to be used, we'll get back to that on the next slide. But as a practical matter, conducting a deposition at least a week before a paper is due makes a lot of sense, because you'll need the deposition testimony as well as a transcript so that you can cite to it in your paper. So if you're the patent owner response, or if you're the petitioner, for example, the reply brief. This is also where it would be very wise for the deposing party to order a rough transcript of the deposition so that you don't have to wait for the final transcript to actually begin, inserting placeholder cites and finalizing your brief. So as shown on the slide, in addition to conducting a deposition more than a week before a paper is due, the deposing party must also file a notice of the deposition at least 10 business days before the deposition. Now, this is a bit different than depositions in district courts, where typically you only serve a notice of deposition on the other side. But in a PTAB case, the advance notice actually allows the board to ensure that a member of the panel is available should the parties need to contact the board to resolve a dispute during the deposition. Now, of course, as a practical matter, the parties are, of course, strongly encouraged to resolve disputes that arise during a deposition on their own without involving the board if possible. So the timing or scheduling of a PTAB deposition makes a lot of sense when you think about the discovery periods that are available to a patent owner and the petitioner in an IPR proceeding. So what I have up here on this slide is a visual representation of the typical life of an IPR proceeding. And what I want to focus on is what I have boxed in dotted line, which shows 3 separate discovery periods. So there's a first 3-month discovery window for a patent owner to develop and file its patent owner response. Then there's another 3-month discovery period for the petitioner to file its reply brief. And finally, there's a 1-month discovery window for the patent owner to develop and file its SIR reply. And so in each of these discovery periods where the other side has filed an expert declaration, you can cross-examine the other side's experts with respect to the opinions in that declaration. So for example, if the petition was supported by an expert declaration, which it often is, in the first discovery period, the patent owner will have an opportunity to depose that witness before filing its patent owner response. And just as a note, because the deposition takes the testimony of a witness or that witness previously testified by affidavit or declaration, that is why the deposition itself is referred to as a cross-examination, as opposed to, for example, a direct examination or something else altogether. So regarding the default time limits for a deposition, the key number to remember is 7 hours for cross-examination, which is consistent with the 1 day of 7 hours you may be familiar with under Rule 30 of the federal rules. Now in practice, most depositions in PTAB cases rarely use the full 7 hours, at least in my experience. And in practice, redirect and recross are actually extremely brief if conducted at all. But if they do occur, you get 4 hours for redirect and up to 2 hours for recross. Now you may be wondering, what about direct examination? Well, as I alluded to, declarations submitted by expert witnesses are considered direct examination. Now, direct examination by deposition is actually permitted, but it's typically very rare and usually reserved for depositions of third parties. So I personally have not dealt with them, but in case you're curious, the time limits are basically the same. In other words, 7 hours for direct examination, 4 hours for cross-examination, and then finally another 2 hours for any redirect. So in terms of the form of testimony, testimony must be in the form of a transcript, which is not surprising, and must be filed as an exhibit. And typically the exhibit is going to be filed at the same time as the paper it supports. So for example, the deposition transcript of the petitioner's experts will typically be filed when filing the patent owner response. So there's also the possibility of video recorded testimony, the key word being possibility. So as shown on the second bullet point here, the rules state that the parties may agree to video recorded testimony, but may not submit such testimony without prior authorization of the board. So this is actually a bit different from district court litigation, where in my experience, it's pretty common to take video recorded depositions and where there is no default rule requiring prior approval by the court, at least so far as I'm aware. And so, because this is an area where PTAB cases differ from district court cases, I'm going to give it just a little bit of attention. So again, as shown on the slide here, there are two parts, 1 and 2. And the first requires that the parties agree to video recorded testimony. Nowadays with depositions being routinely done by remote means, I think it's pretty common to request video recording. And so I guess I haven't seen this being an issue. But to the extent the parties cannot agree to use video recording, the board has in the past granted contested requests. But keep in mind that even when the board has done so, there is still that second requirement, which is that a party must still obtain authorization from the board prior to submitting the video recorded testimony. So here on this slide is an example where the board actually authorized the submission of video excerpts. And the case is Specific Markets versus Ignite USA, which is a PTAB opinion from back in 2015. And in the Specific Market case, the patent owner had represented that the total temporal length of 6 video excerpts was about 13 minutes, so not very long. And the board ultimately allowed the submission. And, I think the takeaway from this case is, a party requesting authorization to submit video recorded testimony should identify how that testimony would aid in the development of a fair record and or aid the board in assessing the credibility of the witness. And conversely, a party opposing a request to submit video recorded testimony should provide substantive reasons why the video recorded testimony would not help in the development of a fair record and would not help the board in assessing the credibility of the witness. So in the Specific Market case, what happened was that the petitioner actually urged the board to deny entry of certain video excerpts, initially asserting that they would delay the IPR proceeding. But when actually pressed by the board, the petitioner admitted that the submission of limited video testimony would not actually affect the schedule in the IPR. And so perhaps this was, a unique example where the limited nature of the video testimony made it more likely that the board would allow the submission. And so that brings us to our next topic, which is deposition mechanics. So one thing that's different about a PTAB deposition is its limited scope. And that limited scope is important because it forces you to use a different strategy in a PTAB case, I think, compared to a case in district court. And we'll come back to this briefly in a later slide. But for now, what you need to know is that for cross-examination, the scope of examination is limited to the scope of the direct testimony. In other words, the deposition is limited generally in scope to what the witness said in his or her declaration. And likewise, of course, the scope of redirect is limited to the scope of the cross-examination. So now what happens if the opposing party exceeds the proper scope of cross-examination? Well, in that case, you can and you should object. And this is where it behooves the defending attorney to be familiar with the record so that they can timely object should the questioning attorney stray outside the scope of the witness's prior testimony. And that, I think, is a nice transition to our next slide, which is objections. So regarding objections, the rules provide that any objection to the content, form, or manner of taking the deposition is waived unless made on the record during the deposition and preserved in a timely filed motion to exclude. So one area or another area where PTAB depositions differ from district court depositions is objecting to questions posed by the other side. So, I'm sure there are some exceptions, but generally I would say that there is more leeway in district court for a broader scope of objections as compared with the PTAB. And the reason for that is, the board tends to frown upon long-winded objections that help to coach the witness. At the same time, the PTAB requires that objections be made during the deposition or you'll waive the objection. For example, the board has certainly in the past denied motions to exclude where an objection was not made at the appropriate time. And so, I think the best rule of thumb is, first of all, don't lose the opportunity to make an objection because you'll waive it if you don't object. And second, when you make an objection, say objection and whatever the one word reason is. And in case it's helpful, note that the PTAB trial practice guide actually contains examples of proper and improper objections. And so straight from the trial practice guide, examples of objections that would be properly stated are, for example, objection form, objection foundation, and objection relevance. And examples of objections that would not be proper are, for example, objection vague, objection take your time answering the question, and also, objection look at the document before you answer. Now, not surprisingly, the most commonly used objection if you're objecting properly is going to be objection form. And, going back to what we were talking about, I believe 2 slides ago, if the questioning attorney is clearly going outside the proper scope of cross-examination, what I'll typically do is I'll object and probably say something along the lines of, objection, I'll object to those lines of questioning as beyond the scope of Dr. So-and-so's declaration testimony, or something to that effect. So a potentially useful feature at the PTAB is that the PTAB avails its judges to make on-the-spot rulings over the phone when there are disputes during depositions. And going back to what we were talking about earlier, that's one of the reasons that deposition notices are required to be filed. In other words, to ensure that at least one PTAB judge is available should the parties need to contact the board to resolve a dispute during the deposition. And so, for example, if there's a dispute regarding whether the assertion of privilege was proper, you can call the board and try to get an on-the-spot ruling on the issue. Likewise, if you think the questioning attorney is consistently going beyond the scope of the witness's declaration testimony, you might consider stopping the deposition and call on the board to get a ruling on whether the questions being asked are proper. And so typically the way this works is that while you are in the deposition, you email the board and the board will typically email back within minutes asking for a dial-in number, which the judges will then use to dial in. Now, in the age of Zoom depositions, unless of course instructed otherwise, I think it's probably fine to just send the login information for the Zoom meeting that's actually being used for the deposition. At least that's what I've seen done in the past, and it hasn't been an issue. Keep in mind also that if you want to be able to take advantage of the board's on-the-spot rulings, you'll need to make sure the deposition is of course scheduled during business hours. For example, the PTAB has, at least in the past, suggested that depositions on the West Coast be scheduled early in the day, given the time difference with the East Coast. So there's also the question of what attorneys can or cannot discuss with witnesses during breaks during the deposition. So, some district courts will not let counsel defending the witness discuss the substance of the testimony. Others, may have fewer restrictions. The PTAB has actually come down squarely on the side of no witness coaching during breaks. And so if you are taking the deposition, and particularly if you think there's coaching going on, or if you think the other side, isn't familiar with the PTAB rules, it's probably worth inquiring about any discussions the witness may have had with the defending attorney after the witness returns from a break. So on the slide here, I emphasize the word cross-examination because at least in the past, there's been some ambiguity as to when the prohibition on coaching the witness applies. In other words, does it apply before or during redirect examination? Well, the board actually resolved that specific issue fairly recently. So in July of 2019, the board designated as precedential a 2014 PTAB case, Focal Therapeutics. And the question in Focal Therapeutics was whether the prohibition on conferring with the witness applies only to the initial cross-examination, or whether it applies to the entire deposition, which would of course include redirect as well as any recross. And what happened was that the board in response expressly stated that cross-examination refers to either cross or recross, such that the prohibition on conferring with the witness only applies during cross and recross, but not before redirect begins. In other words, you are technically allowed to confer with your witness to prepare for redirect examination. So our third and next topic is the role of PTAB depositions. So the role of a PTAB deposition is, I think, quite a bit different than a typical deposition in district court litigation. So first of all, PTAB depositions and IPRs are testimony, and deposing and imposing parties' experts is typically the only form of discovery you're going to get. And further enhancing the role of a PTAB deposition is the fact that the board generally does not permit live testimony at its hearings. So for example, if the witness does not provide the necessary or desired testimony, either through a declaration or at the deposition, usually there is no other means for providing that information to the board. The lack of live testimony also means that there is not going to be a second chance for the witness to clarify, ambiguous statements or to otherwise supplement their testimony. But this is, in contrast to district court litigation, where a deposition witness is likely going to have a chance to supplement their testimony because obviously if the case goes to trial, they may choose to take the stand and testify again live before a fact finder. So in other words, a judge or a jury. So the issue or the topic of live testimony It's a little off topic, but because of the general lack thereof in PTAB cases, I want to spend at least some time on it. And specifically, I want to briefly discuss a PTAB decision that the board designated as precedential in March of 2019 that clarifies when live testimony might be permitted. So the case is K40 Electronics, which involved an IPR filed back in 2013, which I believe back in 2014 was actually the first IPR where live testimony was allowed. So what happened in K40 Electronics is that the patent owner had submitted a declaration from the sole named inventor, whom the patent owner was relying on to antedate both of the prior art references that were at issue. The patent owner then filed a motion with the board to present live testimony from that named inventor. And so the board articulated, as shown on the slide, two factors to be considered in determining whether to permit live testimony. So the first factor is the importance of the witness's testimony to the case. And the second factor is whether the witness is a fact witness or an expert witness. And applying those factors, the board determined that because a successful antedation would avoid all of the asserted prior art, the inventor's testimony may well be case dispositive, which of course weighed in favor of allowing live testimony. Regarding the second factor, the boards noted that the credibility of experts often turns less on demeanor and more on the plausibility of their theories. And in contrast, it noted that courts typically make credibility determinations to assess the candor of fact witnesses. And here, the inventor was a fact witness, which also weighed in favor of allowing live testimony. So this PTAB case is important, I think, because again, it helps clarify when live testimony might be permitted. So in this K40 Electronics case, the board stated that it envisions live testimony will be necessary only in limited circumstances, and that it intends to approach requests for live testimony, quote, on a case-by-case basis. Now, notably, by relying on the fact that the witness or the inventor was a fact witness, the board also, I think, implicitly suggested that live expert testimony will generally not be permitted. And, because most PTAB depositions are depositions of experts, this further confirms, I think, the importance of a deposition in an IPR proceeding. In other words, in all likelihood, there won't be a second chance for a witness to provide additional testimony. And that leads us to our last and final segment, which is strategic considerations. So under this broad segment that I call strategic considerations, there are two subtopics I want to cover, which I call leave open the gaps and sound bites. So instead of including slides for this segment, I want to just talk through the two subtopics. So under the subtopic, leave open the gaps, there are really 3 points that I want to hit. So the first sort of preliminary point is, first of all, a PTAB deposition is not a fishing expedition. So in district courts, one potential goal of a deposition is to, learn as much as possible from the other side's experts and, try to find out what that person is going to say later to a judge or a jury. You might also try to nail down the other side's experts on specific positions ahead of trial. A PTAB deposition, in contrast, is much more focused. So as I mentioned earlier, under the board's rules, the scope of a PTAB deposition is limited generally to what the witness said in his or her declaration. And so rather than using the deposition as an opportunity to explore or test theories, a deposing attorney, in my view, should really consider asking lines of questions that are carefully planned ahead of time. And to do that, one, I think, good approach is to use the expert's declaration as a roadmap, analyzing it for issues that are worth digging into. And the key is worth digging into. Which leads me to my second point, which is that there are risks associated with conducting a deposition in the first place. So what do I mean by that? Well, when analyzing the expert's declaration, you might notice that there are weaknesses in the expert's opinions. For example, in the case of a petitioner, the expert may not have fully explained where a claim limitation is shown in a prior art reference. And so where you have a situation like that, where there are deficiencies in the expert's direct testimony, conducting cross-examination via a deposition could allow the witness to actually fill in the gaps, which is definitely something that you do not want to happen. Now, in contrast to the PTAB, a witness in district court will likely have a chance to clean up the weaknesses later down the road. And so the weaknesses may be something worth asking about now in order to lock in the expert's testimony. But at the PTAB, you may be better off leaving the weaknesses alone. So keep in mind again that in all likelihood, the deposition, in other words, a PTAB deposition is the last time a witness is going to have an opportunity to provide testimony in the case. And so by asking the witness about a weakness in their declaration, it opens the door for the expert to elaborate on their opinion. On the other hand, if you leave the weakness alone, the expert won't have that opportunity. So the expert won't have that opportunity, and then you can go back to the board and point out the weakness in one of your papers. So, long story short, what's important, I think, is that you don't ask overly broad questions that will allow the witness to elaborate on or otherwise enhance their existing opinions. And in fact, on the very extreme end, you might even consider avoiding a deposition of the other side's expert altogether. That's probably something that would very rarely, if ever, happen in district courts. But at the PTAB, given the right circumstances, I think it's certainly something that you might consider. And so what I think this conveys is that sometimes less is more in a PTAB deposition, which is my third point. In other words, while it's important to cover key areas of the witness's declaration, I think it's arguably equally important to consider whether or not to explore certain issues. And, the reason for that is twofold. First, it prevents the witness from elaborating on or supplementing a weak point during cross. And second, and relatedly, because the scope of redirect is limited to the scope of cross, the other side should not have an opportunity to rehabilitate the witness on the weak points. Now, on the other hand, if the questioning attorney does touch upon a weak point during cross, if you are the defending attorney, should certainly consider using redirect to your benefit. So keep in mind, again, that because the witness is unlikely to testify at the oral hearing, the deposition is going to be likely your last opportunity to supplement the record, rehabilitate the witness, and generally clarify any ambiguities in the witness's cross-examination testimony. Now, of course, even if the questioning attorney does not open the door, the defending attorney may still try to introduce new opinions or evidence on redirect. And, if that happens, the questioning attorney should, of course, object to the line of questioning and hope that the board will strike or otherwise exclude the improper new opinions. Now, in the case of a petitioner, the petitioner may also try to fill in the gaps in its petition by submitting a new declaration with their reply brief. So the PTAB has taken a negative view of offering new opinions and evidence in a reply, but if for some reason the PTAB or the board allows it, the patent owner will have a chance to separately depose the witness on any new opinions or topics. And so if you recall back on slide 7, that would be the second patent owner discovery period. So finally, the second subtopic I want to discuss in this last segment is sound bites. So once again, the purpose of a PTAB deposition, in my view, is not to learn from the other side's expert. The main purpose, in my view, is to pull admissions or sound bites. And one way of thinking about it is that a PTAB deposition is sort of like cross-examination in a district court trial. In other words, you should think about it like it's live testimony. That there's no dry run. You go straight from the expert's declaration to the deposition, and typically that's it. And so you want to be able to elicit a response that can be easily quoted in a brief. And usually that's going to require that you rephrase questions in different ways to draw out a clean response or what I call a soundbite. Also keep in mind that because the ultimate audience for the deposition transcript is a panel of judges that have technical backgrounds, in the case of a PTAB deposition, it can be the case that extremely detailed or technical questions may be appropriate. Certainly, I think much more so than in a district court proceeding, where typically your audience is going to be a jury of laypersons. Now, in addition to getting good sound bites for quoting or citing to in a brief, another purpose, I think, of getting good sound bites at a deposition is that you can place that testimony in front of the board as a demonstrative. In other words, in a PowerPoint slide during the oral hearing, which of course can be a very powerful way to make use of deposition testimony that is helpful to your case. Now, to ensure that you can actually do that, it's important that you actually cite to or otherwise reference that testimony somewhere in one of your briefs. And the reason for that is pretty simple, which is that the board does not allow new evidence to be introduced at the oral hearing. In fact, the board requires, or at least strongly encourages, that your demonstratives indicate, usually at the bottom of each slide, where that evidence shown was presented earlier in the record. And so with that, I think that concludes the presentation portion of today's webinar. Just a couple of quick disclaimers as shown on the slide. So the presentation is for educational purposes only. The views expressed are my views, not the views of Armond Wilson or its clients. The information presented are not legal advice. And finally, no attorney-client relationship is formed as a result of merely attending this webinar or otherwise reviewing these slides. So I believe we may have a CLE code for Virginia. Ashley or someone from the VPG team, is that correct? Or is that still pending?
It is still pending. I suspect that we will probably get it in November because they are a little bit behind right now. I just received the one for October right now. So yours would be maybe a few weeks.
Okay.
I'll notify the participants.
Okay, sounds good. Thank you, Ashley. So thank you again, everyone. It's been a pleasure to have this opportunity to talk to you today. If there are any questions, I can try to answer them in the time we have remaining. And if not, my contact information is here on this slide.
I actually do have questions.
Okay.
Oh, well, let me go ahead and read off Kevin McNish first. So first of all, thank you for speaking for VPG. I really appreciate this. This has been very informative and bring back a lot of memories too. So Kevin's questions here is, what tips do you have for dealing with evasive witnesses?
Well, Kevin, that's a great question, and a question where if anyone else has any advice, I'd be happy to hear it. It's difficult dealing with an evasive witness because sometimes there's not much you can do. If a witness really isn't answering questions that are really questions they should be answering, meaning uncontested questions, one approach would be to take a hardball approach and try to call the board and get an on-the-spot ruling on whether the expert is improperly refusing to answer questions. Even if the board doesn't force the witness to provide answers to certain questions, it may at least get the ball rolling, and putting the witness through that ordeal may get them to actually answer or open up a little bit. I think in practice, though, what you really have to do is sort of try to change your approach to your questions, either during the deposition, which can be difficult, or if this is, for example, the petitioner's expert, where you're going to potentially get another deposition to depose them on their reply declaration, I would change my approach to some extent to not so much get admissions, although that is something you should aim for, but at least at the minimum, try to nail them down on their opinions, because sometimes you'll deal with a petitioner where they're going to try to change your opinions down the road. And so by at least using the deposition as an opportunity to nail them down on those opinions, it'll make it harder for a petitioner to change their theories. So long story short, it's difficult, but if anyone else has any advice here, I would certainly be, happy to listen to that.
Well, thank you for answering that question. The questions that I have is that, like we've talked about, I've done primarily district court cases before. And then, so depositions is a much wider, usually we have multiple depositions and with fact witnesses, 36 and expert witnesses. But in PTAB cases, primarily, I've only seen expert witnesses, the expert testimony. And sometimes district court, like practitioners, they would come in and wanted to say that they want to have a fact witnesses deposition. In your experience, how often have you seen fact witnesses being deposed in PTAB cases?
I don't think it's very common, but one situation where you might have a fact witness is, for example, where there's a swear behind and where you might have the inventors being deposed. And so that's probably the most common situation that I've seen. But another potential situation where you might have a fact witness is where, for example, there are issues dealing with real parties in interest, where the board might allow limited discovery into that issue. But you're right, and by far, experts are the most common deponents in a PTAB deposition.
I see. So Steve Olson, must redirect be taken immediately after cross?
So I think the answer to that is no, but one strategic reason to do the redirect directly after cross is it avoids any implication that you may have coached a witness. And so technically you are allowed to confer with your witness to prepare for redirect. But as a practical matter, it's possible that the board may give, if they suspect that you may have coached a witness, it may give the board reason to, give less weight to that testimony. And so that's one of the reasons why, in my experience, sometimes we go straight to redirect after cross.
In your experience, do you find any particular, do you prefer PTAB deposition over district courts, or what are your thoughts on that?
As a general matter, and I don't think this is a preference for either PTAB depositions or district court depositions, but I do think expert depositions are a little bit more exciting because you are trying to nail them down on certain points and get admissions versus, if you're doing a fact witness deposition, either in district courts or the PTAB, you're more looking for facts and it's a little bit more routine. You don't really have to be on your feet quite as much. But in an expert deposition, you really do need to adjust your approach as you're doing the deposition. And so it's a little bit more exciting in my view.
Yeah, in fact, in district court is like you said earlier, it might be a little bit more efficient and expedition.
Correct.
To figure out what the facts are, piece them together versus like you already know that you already have the expert declaration. So.
Right.
Well, does anybody else have any questions? I just thought this was really informative, so thank you so much.